like this because it's gone on for a while, and you've had these defendants who are in custody and haven't been given a bond. So I think that, that would be a nightmare situation. Great question.
Yeah, I run out of alternates. As far as I'm concerned, that's the end of the day. That's a mistrial, and that's a big loss for prosecutors. Like you said, I don't know. Sometimes you get judges that make it really tight. You try to tell them we need a lot more, and they're like, no, 14's enough, 16's enough, and then things happen, and you're down to one last one, or no alternates left over, and it could really be a nail biter. I know Gene Rossi knows that, but I also know Gene Rossi knows this. David Gaffney from YouTube says he still wants to know if the state is successful, Gene. Will the defendants in YSL as a record label lose all assets, even legitimate assets such as record sales? Good question.
Well, if they can show that the proceeds of their enterprise were used to fund the record label, then you could trace those assets. It's this classic money laundering, and you're going after substitute assets or assets that are traceable. So yes, it's possible that those proceeds of the record label could be forfeited.
Okay, excellent. Yeah. And that would be a whole procedure, right? Afterwards, I assume a court would have to go through all of that to make that kind of connection, or does a jury decide that? I assume it's a judge.
At the federal level, you can have the jury decide whether certain assets are forfeitable, or a defendant generally waives it and do the forfeiture rulings at the sentencing.
Very interesting. Okay, great. Afi, let me go to Teresa Trice from YouTube. And she asks, I assume it's a she, given the majority of witnesses who have testified to charges dropped for this case that are apparently brought back. Let me see if I get it right. Witnesses have testified to charges dropped, and for this case apparently brought back. How does that affect the trial? I think what's being asked there is that a majority of the witnesses have testified and had charges dropped or received plea agreements and may be coming back to testify. How does that affect the trial? I think that's the import of the question.
I got it. Fantastic question. And this goes back to the importance of opening statements. I think the second defense attorney that got up, he knows that we're going to have a lot of witnesses who've taken plea deals. And he said something, he talked about Fulton County, and he talked about all of the prosecutors' witnesses. He said, when they get up there, these are their men in blue. And he really emphasized how horrible a reputation that Fulton County jails are, and how you just do not want to be in Fulton County blue. And if you're faced with that prospect of being in Fulton County, you'll say whatever you need to do so you don't have to be in that Fulton County blue. So I think that, that was really good that the defense counsel said that, because that's the nugget that I've held on to even after all this time.
Yeah, I want to answer that, and I'm going to flip this one to Gene because I think it's a really good question. It really depends. I think somebody had mentioned this before, how your witness testifies, how credible they seem to be. Of course, the defense is going to attack them, that they have a motive, an expectation of benefit, they call it, in order to get a favorable resolution from the government. But many times the feds included, Gene could talk about that, use those very kind of witnesses, especially in a RICO case, in order to testify. By definition, they're involved in bad things. Gene, what do you think about using those witnesses, flipping them and giving them light plea agreements? Do you think that they're valuable? Does it depend on a case-by-case basis? Thoughts?
It's a case-by-case basis, and I'll give you a couple examples. I had one drug trial, organized crime and drug trial, where we had two witnesses that pleaded guilty to perjury before a grand jury. In our trial jury, the jury loved them. They admitted they lied. They admitted why they lied, but their demeanor and the way they explained things, and that their testimony was corroborated, the jury believed them and they were found guilty. Case I just had, we had witnesses that were given immunity that had admitted they lied. I tried to attack them, but at the end of the day, it just depends on a case basis, whether a jury will believe what they say, and will they say something that is corroborated by uncontested evidence, like a document.
And Alexa Rose from YouTube, I think that pretty much answers your question. It seemed very similar about if they plead guilty and testify, how does that affect the state's case? So I think we knocked that question off as well. Afi, let me ask you, Inquiring mind from YouTube wants to know, how does a judge get selected for a high-profile case? With all due respect, this judge seems overwhelmed.
It's different in every jurisdiction, but usually it's sort of. I'll just give you an example for. When I first got out of law school, when I was a public defender, it would depend on the day that it's kind of like a lottery. If it was a murder, for example, it would depend on who was on duty, the duty judge when the murder was committed. It really depends by jurisdiction. Sometimes jurisdictions are divided into judges who handle just arraignments, judges who handle felonies, judges who handle misdemeanors. So it's usually a lottery system. You don't get to select a judge because you always want to have just an appearance of a neutral and detached magistrate, which is the judge. So from my experience in different jurisdictions, it's kind of like a lottery system. And it just depends on, the luck of the draw, if you will.
All right, guys, I'm going to ask each of you this question because it's deep and maybe complex, and we may have different points of view. Lisa Simpson Rules from YouTube asks, what are the most probable causes for a future appeal if the jury convicts them? There have been a number of fishy things so far, in my opinion. Afi.
I think, it was mentioned earlier. I hate to use the word, I'll just say it, the sloppiness of the prosecution. I think they've slipped a number of things before the jury that they really shouldn't have. And I think the judge has been, the judge is getting a little bit more stern with them. But, just from day one, when we started with the opening and you put someone's criminal charges up there. And, that was a complete violation. I think Steele got up there and did what he was supposed to do, call for a mistrial right away. But I think, and as the trial goes on, they're going to, if they don't tighten up and they continue to be sloppy, they're going to expose themselves for reasons for appeal. And, they just started out of the gate with day one with that.
Yeah, and things can become cumulative too. Sometimes an appellate court will say, after all of these things get that. But Afi, I want to add, one thing. Let's be clear, in my opinion. You guys tell me if I'm right or wrong about this. I think that that's the biggest, most egregious error that's been done because it violated the cardinal rule of burden shifting and commenting on a defendant's right to remain silent. In my mind, that mistrial motion, though, made by the defense, which is something that they had to make. How much, Afi, do you believe they were crossing their fingers saying, Judge, please don't grant it. Please don't grant my mistrial motion. I want to preserve it for appeal, but I want a shot at trying to win at this trial.
That's how I would have felt. Please don't grant it. I have to do this. I have to preserve this, but I think we're going to do pretty well at this trial, because the problem that the prosecution has in this trial is, of course, losing their jurors. They're piecemealing so many things together, and it seems like the issues that they're focusing on seem so minute. So I think that the defense definitely wanted to continue, but they had to do what was in the best interest of their client, which is preserving this matter for appeal.
Gene, I think you're going to agree with that comment that Afi had as well, but please opine on that. And what about the RICO law, the stretching of the RICO law, the use of the lyrics, the introduction now of all this other evidence that typically would not be admissible if it wasn't for a RICO charge? What are your thoughts about the success on appeal?
I want to address the appeal issue. My experience is a lot of appeals are result in reverses because of bad jury instruction. The elements of the crime were not properly presented to the jury. I've had a couple of reversals where, as a prosecutor, I got a little greedy and the jury instructions were a little too aggressive. So that's one area. Second area is what we've just been talking about, the burden shifting. And since you got some educated listeners here, in 1963, Griffin versus California, Supreme Court said a prosecutor cannot comment on the failure of a defendant to take the stand. Before that, they could, but then they said they couldn't. And then Doyle versus Ohio is when a defendant invokes the Fifth Amendment during an interrogation, you can't comment on that. So what happened in that opening is she kind of touched on both of those landmines, and I agree, I don't want my motion for a new trial granted. I want it denied because I want two bites of the apple. one on the opening statement and two on the hung jury or acquittal. And the last thing is evidence. Allowing evidence in or excluding it are also bases for reversals. I go back to Bianchi. Other crimes evidence. Prosecutors get very greedy on putting in other crimes evidence. And Bianchi has a case where they complimented him because he held back a little bit and didn't get greedy.
Yeah, definitely. And I think that that's where I bring in the RICO piece to it, because RICO allows so much more evidence to get in there that if it's a weak case and they get greedy on that evidence, you may be right into that situation that you're talking about. A lot of landmines for sure, guys. Okay, awesome commentary. We're going to take a quick break. Don't go anywhere. We're still waiting for that jury to come back, but please get us some of your questions on YouTube and social media and the chat sections, and we'd love to be able to answer them and appreciate you for sending them in. We're going to be right back.
At Fairway Subaru, we've always believed in giving back to our community. That's why the Subaru Share the Love event is so special.
So when you buy or lease any new Subaru during the 2023 Share the Love event, Subaru and Fairway Subaru will donate $325 to charity. Plus, for a limited time, get 1.9% financing on a great selection of new Subaru Outbacks at Fairway Subaru. Share the love today at Fairway Subaru, where we're always open at fairwaysubarusc.com.
Okay, we're still waiting for that jury to come back on their lunch break. You know how it is in a courtroom. Hurry up and wait. But anyway, it gives us an opportunity to go through the racketeering trial against rapper Young Thug and the co-defendants, and they were due back in court at 1:30 Eastern Time. We'll wait to see when that happens. Court resumed today after extended hiatus following the stabbing of a co-defendant in the case at the Fulton County Jail. And while we wait for them to come back, again, we're taking your questions with our great legal panel. So if you do have any questions, feel free to post them on YouTube chat or on social media. Okay, so Sway, S-W-A-E, I hope I got this right. Dollaz, D-O-L-L-A-Z, Sway Dollaz, from YouTube says, Gene Rossi, if the state loses, will the feds refile charges?
Well, practically, no. Academically, yes, because the double jeopardy clause is sovereign centric. If a state tries a case and they lose, the feds, even if it's a similar charge, identical, because it's a different sovereign, they can try him. But practically, no.
And just for me to round that out, Afi, I don't know how you feel, but I have seen instances in which the prosecution did not go well stateside and the feds decided to pick it up, like Gene says, on it's not double jeopardy because it's a different sovereign, and typically they're different charges like civil rights violations or things of that nature. What do you think, Afi?
Yeah, it's interesting. For some people, it's very unfortunate. I remember seeing a lot when I first started out. A defendant would be thinking he's getting a win because the state would unceremoniously dismiss a charge and he'd remain in custody, but only to have the matter picked up immediately by the federal government. So it happens all the time.
Yeah, Gene, let me play this back with you because I think this is a good question, can be fleshed out a lot. I've also seen circumstances and been involved in them where we are the ones doing the investigation. We're the ones that build the case. We're the ones that file the charges. And the next thing you know, the feds come swooping in and file their own charges, and they wind up taking the case. That did not happen here, to my knowledge, in any way, shape, or form. This doesn't seem like the kind of case, if the government loses it on stateside, that the feds are going to want to pick up. A lot of witnesses, a lot of tangential pieces of evidence, and we know one thing about the feds. They never want to charge a case that they could possibly lose.
They can't win.
And you are absolutely right on that. There are a lot of prosecutors at the federal level who have an affliction called timidity. But here's the thing. I would say that given Afi just hit on a nail on the head, I think there's no sense that they're waiting in the wings. The feds are waiting in the wings. You know, I call it like a blister. They show up when the work's done. Once the state folks do all the work, they say, oh, we'll take it. That's happened. I don't see that occurring at all. And the main reason is this is a long trial, a lot of witnesses, a lot of transcripts that a prosecutor at the federal level will have to eat inconsistent statements. It's just a hot mess. So they're not going to go near it.
Funny, Gene, I never told you the story. I had one where we investigated for many months a bank robber who had robbed the plethora of banks, and we were going in to make the arrest. We did the right thing to call our partners and say, hey, I want to let you know we're going in and make an arrest. And our guys went and brought the guy out, and the next thing you know, a federal agency grabbed the guy and said, thanks very much, and they took him away and charged him. And we were like, literally took him out of the hands of law enforcement. That's how it can get. Okay, Afi, does, if the state loses, will YSL, and this comes from Purple Dinosaur, be able to be compensated for their loss of revenue?
So no, that would be a civil matter, and this is a criminal matter. I think the only way that I could see some type of claim if there was some sort of malicious prosecution. I don't think that that's anything that's viable here. So I would just say no. You know, I don't. Purple Dinosaur. That's a great question, but I can't see it. Gene, Bob, maybe you guys can help me out with that.
Yeah, I personally, Gene, I'm not going to see that. Prosecutors are given a tremendous amount of immunity and discretion, and that would have a significant chilling effect unless they could show there was a custom or practice, a policy of malicious prosecution, false arrest or something of that nature, which is very hard to prove. What do you think, Gene?
Well, I had to settle the case. if at the federal level, if you bring a case that is in bad faith or it is frivolous or both, and you have an acquittal or there's a dismissal, there's a federal statute that allows you to get attorney's fees. It's very hard, it's very difficult, but that's one remedy. But I don't see that here.
Yeah, and just to round that out, the statute you may be referring to is 42 U.S.C. 1983 and 1988. That is the civil rights statute, which again, if you are found not guilty as a favorable determination, and you could show that that injury was a result of a custom, practice, or policy, those are the real words, based on the decision named Monell, then you have a shot at it. But they're entitled to all sorts of qualified immunity. It's a very, very difficult prospect. But great question. Afi, does the prosecution have a case for witness tampering based upon a defendant being stabbed in custody? And that comes from 23F23 from YouTube.
Okay, so I'm assuming this is about the Shannon Stillwell Jackson issue. So you would have to do an investigation on the young man who allegedly stabbed him, and you'd have to look into, were there orders given? What is the reason? Was it just the result of a dispute in-house? There's just so many things that they'd have to look into. I think that if there was a case for it, that would be, they could do it. But for me, I would wonder if they could use that evidence to show that Stillwell is a part of a gang, and it's witness tampering, and it was maybe done by one gang member against another gang member. So I think that could help the prosecution in that way. Yeah,
I was thinking the same thing. Gene, this is an extremely deep and philosophical question, so be careful about how you answer it. Danny from YouTube says, since this case will drag out, should the judge respect the court's time more? And the reason I say it's deep philosophical is that the judge really is the court, but but not really. The judge is, but isn't. What do you think?
I'm a little confused by the question. Could you repeat it, please?
Yeah, since the case will drag out, should the judge respect the court's time more?
You mean respect the court's schedule? Is that it?
I think so, yeah.
Okay, let me tell you this. I know both of you have been in front of judges. I've said this many times. Judges guard their schedule almost as much as their own family members. It is a precious commodity. So at some point in time, probably March or April, this judge who I'm looking at right now, he's going to say, listen, I have a schedule. The jury has a schedule. I'm going to rein these prosecutors in, and I'm going to cut this trial by a month, maybe 6 weeks. There will probably be a moment in this trial when he does that. And I can't wait till it happens, because I don't care what kind of case it is. It should last 6-7 months.
Yeah, for sure. But like they say, you dance with the one you brought, Gene Rossi. Okay, we're gonna take a break here in a long crowd. That's my advice for 2024. We'll be right back.
Check out this week's Lidl deals. Sanderson Farm chicken breasts are $1.89 a pound. Green seedless grapes are $1.49 a pound. And Butterball ground turkey is $2.99 a pack. Shop today and save. Lidl.
Okay, the jury's still out in the racketeering trial against rapper Young Thug and co-defendants. They are due to be back at 1:30 Eastern time. We're waiting, but we are answering questions from the audience. So, Afi, let me go to Alexa Rose. How are I think we talked about this a little bit earlier, but those who pled guilty, how is that going to affect the state's case?
So again, I kind of mentioned already about how we had the second defense counsel on an opening. He kind of already has planted the seed that these witnesses are going to be witnesses who are in Fulton County blue, and basically they'll say anything to not have to wear the Fulton County blue and to be free. So he's kind of planted a seed already to kind of discredit these witnesses' testimonies. But again, as Gene mentioned, sometimes jurors love what I call snitch testimony. It just depends on how they answer the questions, if there's corroborating evidence, and how they present themselves. So it really just depends.
And let me ask Chanel Holback, and let me go to you, Afi, on this as well. Is there any overwhelming evidence against Williams, like something heavy, quote unquote, murder, assault, felony possession, something that would be so-called RICO?
You know, that's what they're alleging. We haven't seen anything yet, but we've got, again, hundreds of witnesses. But it's not, you don't need the heavy hitters. You don't need the murders. You don't need the armed robberies to be considered RICO. Anything, any act in furtherance of the criminal enterprise can be considered RICO. And I think that's what the prosecution is banking on. They're presenting all of these small acts and saying that, hey, this is RICO. All of these things are going toward the furtherance of the criminal enterprise. But you're going to have to explain that to a jury who, like, you're a jury member, you're a member of the public, but the jury, they think the same. We're all regular people. They're not going to understand that these tiny little acts are in furtherance of a gang. Like, we'll take the mall incident. You know, any jury member can discount that and say, hey, these are just people who don't know how to act in public, you know, don't have the best home training, you know, or we're young at the time, we're silly at the time. You know, I don't know how this is going toward a RICO. So it's going to be the prosecution wraps that up, because most people associate RICO with heavy hitting crimes and violence, or, you know, big drugs, big robberies, big murders.
Gene Rossi, you're a former federal prosecutor where RICO first came into existence, specifically with regard to the organized crime with mafia, and very, very, very effective tool. Some have questioned the use of RICO in charges like this. Does it set a precedent in your mind? And in your mind, does RICO apply in a tier to prove a RICO?
I think focusing on this case, I think you have a quasi-enterprise, but I don't think you have a full-blown enterprise. And is that enough to persuade a jury? You have a lot of, you know, interrelated dots. You have the mall incident. And Afi brought up a good point. Is this a person at the mall that's just having a moment of immaturity and recklessness? Or is this actually connected, and is it directed towards maintaining, promoting, and enhancing an enterprise? That's the key. Are they throwing in overt acts, I call them overt acts, RICO acts, that are wholly attenuated and disconnected, or they are part of a montage and a final mosaic? That's going to be what the prosecution has to do in their closing, and show that it's a mosaic, not some box of pieces of a puzzle that are unrelated.
Well, DC 71 Gene from YouTube wants to know that if these RICO charges in Fulton County are in fact successful, would it set a precedent?
I don't think so, and I'll tell you why. RICO cases are very hard. They're laborious. They last long. I don't care if it's the federal level or the state level. So it's not going to change the desire of prosecutors to use RICO or to stand down. If there's a case for RICO, they will charge it. Won't have anything to do with this case. I will say this.
Everybody's present and accounted for.
Thank you, Sir Ingram. All right, councils, before we go ahead and bring in our jurors, just to let you know what I'm going to tell them, I have some unrelated matters I got to take up just for about 30 minutes at 3 o'clock, so we're going to break right before 3, come back about 3:30-ish, and we'll see where the day leads us at that point in time, just so you know, okay? All right, unless there's anything else I need to take up with you all, I'll summon our jurors at this point in time.
All right, for the jury.
All right, ladies and gentlemen, please be seated.
All jurors present, count 4.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, we're going to continue with the presentation of state's case. Let me just kind of just tell you where we are going to head for the afternoon. We are going to take about an hour's worth of testimony. I have some unrelated business about 3 o'clock I need to take up for about 30 minutes. We'll come back and then we should work somewhere around the 5 o'clock hour thereabouts, and that'll be the conclusion of our first workday, okay? All right, okay. State summary, next witness, please.
Thank you, Your Honor. The state called Richard Randolph.
All right, summon Mr. Randolph, please. Mr. Randolph, good afternoon. So if you would please approach the witness stand, once you get there, turn and face our name and be sworn as a witness, please.
Raise your right hand and swear firm testimony you give the truth, the whole truth, nothing but the truth.
I so swear.
I see. State spelling first last name for the courts.
Richard Randolph. Richard common spelling. Randolph, Randolph.
And good afternoon.
Good afternoon.
Where are you employed?
I'm currently employed at the Fulton County District Attorney's Office.
And how long have you worked at the Fulton County District Attorney's Office?
Approximately 2 years.
And what is your current job title with the Fulton County District Attorney's Office?
I am currently the Executive Deputy Chief of Investigations.
And what are your job duties as the Executive Deputy Chief of Investigations?
As the Executive Deputy Chief of Investigations, I am the number 2 amongst the investigators. I assist the chief with the day-to-day operations of the office and whatever needs may be. I supervise the deputy chiefs along with a team of called the High Profile Difficult Witness Task Force, which is HP+.
And prior to working at the Fulton County District Attorney's Office, were you employed?
Prior to, I was the chief investigator at the DeKalb County Solicitor General's office.
And how long have you been in law enforcement?
Approximately 25 years.
And are you post-certified?
Yes, I am.
I want to direct your attention to this current case. Are you a part of the investigative team assisting with this current case that we are in?
Yes, I am.
And as a member of this investigative team, what are some of your job and responsibilities?
I supervise the investigators that are assigned to this team. We collect evidence, we interview witnesses, we locate witnesses, and anything any investigative needs that are needed with this case.
I want to direct your attention to December 10th, 2023, where you asked to locate and subpoena an individual by name of White Hutchins.
Yes, I was.
And were you able to subpoena Mr. Hutchins?
Yes, I was.
Where did you subpoena Mr. Hutchins?
I located his home and I subpoenaed him in his living room.
And was he present when you went to his home?
Yes, he was.
And while at his home, did you speak with him?
Yes, I did.
And did you speak with him about his testimony, what his testimony would be?
Yes.
And if you could tell us briefly about your interactions with Mr. Hutchins while at his home on December 10th, 2023.
While at his home, they were very nice and cordial. They invited me in. We went inside, and I told them that I was there, and I told them that I was there because of part of this case. And to refresh his memory, I showed him his statement, and that's why I was there, and he looked at the statement.
And I'm going to show you what's already been admitted that states exhibit 190P. Showing you, I believe, it's not on your screen, so you can turn around to the screen above.
Yes, ma'am.
There's a statement. Is that the statement which you showed Mr. Hutchins on December 10th, 2020?
Yes, it is.
And once you show Mr. Hutchins that statement, tell the jury about your interactions with Mr. Hutchins as you showed him that statement.
First, I showed him the statement, and I was using my phone, so I blew up the bottom portion of the signature. And I asked, "Is this your signature?" And Mr. Hudson said, "Yes." And then I proceeded to read the statement to him.
And did you read the statement verbatim as it is on, as it is on the actual statement?
Yes.
And when you read him the statement, what happened?
When I read him the statement, he was familiar. He remembered. This statement. He said he did not type it, but that's his signature. And he told me that he was okay with. He remembered everything verbatim except the last lines of the statement. He did not agree with the last lines of the statement.
And what were the last lines that he said that he didn't remember?
Mr. May was asking them to leave the property. One of the males shouted out that he would come back and shoot Mr. May in his face. And from there, Mr. May told dispatch to call done with the police. He was vague on that part. He said he did not remember that part. He remembered everything else, but not that part.
Just the last sentence.
Just the last sentence.
When you asked him about his signature, what was that interaction? Solely about his signature.
Oh, he was clear that was his signature.
Was there any explanation that was an old signature and not his new signature?
No, he took one look at it and said that was his signature.
Now, you said you read him the statement. Did he ever read the statement himself?
I saw his eyes moving, but I wasn't, I'm not sure that he actually, read it verbatim.
Was it a point where you handed him your device for him to look at?
I held it up to his face and slowly strolled down the statement.
And after reading his statement to him, was there any other interaction regarding his coming to testify?
He was served a subpoena.
It was that.
Yes.
And was this interaction recorded?
No, it was not.
Person open. Outside of the last line, you said that he didn't know where that last line came from. Any other part of the statement did he say that he did not write?
He was in agreement. He was in agreement with the entire statement except the last line.
But he acknowledged that after that last line, that was his.
Objection, meeting, sustained.
However, after that last line, is his signature after that last line?
Yes, his signature's after the last line.
I have no further questions.
Cross.
All right. Any cross?
I don't have any questions.
Okay, all right. Can we permanently temporarily excuse Investigator Randolph?
Permanent, well, temporarily.
All right, Investigator Randolph, I'm going to temporarily excuse you as a witness. You, please don't discuss your testimony with anybody except the attorneys in this case, okay?
Thank you, Your Honor.
All right, thank you, sir. All right, call your next witness.
They call Officer Cogdale to the stand.
What's his last name, Ms. Roy?
Cogdale, C-O-G.
Cogdale?
Yes, L-L. Hey, Your Honor, we'll be starting a new at 9.
All right, Officer Cogdale, good afternoon, sir. Sir, if you would please approach the witness stand. Once you get there, if you would turn and face Sergeant Brown, be sworn as a witness before you sit down, sir.
Please go ahead. Do you swear affirm that the testimony you about to give is true, the whole truth, nothing but the truth?
I do.
I'm seeking just the microphone. State your first and last name.
First name is Curtis, C-U-R-T-I-S. Last name Cogdell, C-O-G-D-E-L-L.
And Officer Cogdale, where are you employed?
Atlanta Police Department.
And how long have you worked at the Atlanta Police Department?
A little over 15 years.
And where are you currently assigned?
Zone 3.
And where's the Zone 3 area?
South side of I-20, all the way down to South Central.
What's up?
Like one or two, I hate this.
Okay. And how long have you been assigned to Zone 3?
A little, about 5 years.
And tell me a little bit about your work history within that.
My career, I started out in Zone 4 as a patrol officer, which is the west side of Atlanta. From there, I went to the Zone 15, and then from there to Apex K9 unit, and then to Zone 3.
And are you post certified?
I am.
And were you post certified since September 2019?
I was.
Direct your attention specifically to September 25th, 2019. What unit were you assigned with?
What unit?
Yes.
Zone 3 patrol unit.
And just tell the jury a little bit about your job and your responsibilities as a patrol officer.
Patrol officer, we respond to 911 calls. You try to help reduce the crime by 5%, and traffic accidents, stuff like that.
And as a patrol officer, certain beat or a certain area within Zone 3.
Assigned to a beat.
Okay. And back in 2019, what beat were you assigned?
309.
And where is beat 309?
It is south of 166 all the way to Cleveland, right there by 75 if you're going east on Cleveland, or 85 if you're going west on Cleveland.
And is there a certain main roadway that sits within Beach 309?
Say it again, I'm sorry.
Is there a certain roadway, is there a major roadway that sits within Beach 309?
It is. There's two. You have Metropolitan, and then you have Cleveland. Parts of Cleveland, right?
Got permission to approach? And I'm going to show what I believe all defense counsel may have, which is a copy of our exhibits. I'm going to show you what's going to mark State Exhibit 28 and 29Q. Do you recognize Exhibit 28 and 29Q?
I do.
And how do you recognize Exhibit 28 and 29Q?
That's part of my area that I patrol.
And is that a fair aggregation of a portion of the area that you control within zone 3?
It is.
And is that a fair aggregation of the area that you control back in 2019?
It is.
Your Honor, this is kind of state by the 10 sections of 28 and 29Q.
Any objections to states 28 or 29Q?
Yeah, just approaching this. Are you going to move to say one?
For the most part.
Any objection?
No, Your Honor.
Hearing none, 28 and 29Q are admitted and may be published as you.
Thank you, Your Honor. And Your Honor, of course, that screen is not on. I didn't anyone from tech just says. But it's, sure, I apologize. The witness screen is not on, it just has Zoom, it doesn't have the images on the screen, so at a break.
There's a reason that one's been disabled, so you're gonna have to use the other one.
Okay.
Okay.
Thank you.
And he can get up and relocate himself if he'd like to, okay?
Okay, thank you for that. All right, if you can just orient the jury, and if you need to stand, you can, to what we are seeing as State Exhibit 28Q.
Say that again.
If you can orient the jury about the map location in 28Q.
Yeah, Metropolitan will have Cleveland.
Where is Metropolitan?
It is.
When you say 21, this is what we're referencing?
Yes.
All right. And you just referenced Cleveland Avenue. This is what we're discussing.
Correct.
Okay. Now, where would your beat, or where is beat 309?
309 would be.
And you can step down if you need to. Okay.
309 is Cleveland from 75 west. So you would have Metropolitan.
Going this way?
Correct.
All right.
And it would stop right there at Springdale, going north.
So this square is 309.
Correct.
All right. And back in 2019, that square was your general 309. Okay. Now, taking back to September 2019, did you have a certain shift in which you worked?
Yes.
What was your shift?
Evening, which is 2 p.m. to 2 p.m.
And is that your current shift now?
It is.
Have you worked any other shift while in zone 3 outside of the evening?
No, ma'am.
I'm going to direct your attention specifically to September 25th, 2019. Were you working that day?
I was.
And were you working the evening shift as you just testified to?
I was.
And where were you? Were you on patrol?
I was.
And where were you on patrol?
That day I was posted up right there in Metropolitan and Peg Road.
The Metropolitan is right here?
Correct.
Right. And,
It's a storage facility.
and coming southbound on Metropolitan, would the facility be on the right-hand side of where were you within that facility?
I was sitting right there at the entrance of the. On my metro.
And what, if anything, did you notice when you saw the resident sitting in trailer southbound on Metropolitan?
I observed the driver dancing around in the driver's seat, and as he passed him, he wasn't wearing a seatbelt.
Okay. And let me ask you this: when you were sitting at the Q Smart, were you facing? Was the front of the car facing Metropolitan?
It was facing in front of Metropolitan.
Okay. And do you recall what kind of red vehicle it was?
It was a red Nissan.
And you said you saw the driver dancing around in the seat.
Correct.
Right. Did you see anyone else from your vantage point at that time inside the vehicle?
There was nobody else in the vehicle.
Okay. As you saw the individual dancing around your vehicle, what did you happen next?
Steady.
The driver dancing around in the vehicle, what did you think happened?
So as soon as he got out in traffic to get behind the vehicle.
And what happened once you got behind it?
Once we approached the end of Metropolitan and Cleveland, I activated my emergency lights to get the driver to pull over.
And did the driver pull over?
He turned on his left signal to turn into the Dollar General parking lot.
And where's the Dollar General parking lot?
It sits on the corner, east corner of Metropolitan and Cleveland.
All right, looking back at our map, where is the general vicinity where the Dollar General will be?
It would be right up here.
Right here?
Yes.
All right. And what happened once the vehicle turned into the Dollar General?
As soon as we entered the parking lot, it immediately continued to the other side of the parking lot, back out onto Cleveland.
I'm going to show you what's been marked as Safety Exhibit 35Q, which should be picture 3. Do you recognize what's the Safety Exhibit 35Q?
I do.
How do you recognize what's the Safety Exhibit 35Q?
That's the Dollar General right there at the corner of Metropolitan and Cleveland.
And is that the same Dollar General that we just referenced on the map?
It is.
And is that a fair and accurate depiction of the Dollar General back in 2019?
It is.
Your Honor, this time say like 10 or 6 to 35Q is that?
Interjection.
Is that the Dollar General?
It is.
And if you can just orient the jury right now to what we're seeing, where's the intersection, and what we're seeing in Safety Exhibit 35Q.
The intersection is right there where the red light is at, so that's the main street you're looking at, that's Metropolitan, and where the red light is at, that's Cleveland. And then he enters the parking lot right there where the gentleman is walking across at the entrance of Metropolitan to the Dollar General.
And is it fair to say that that gentleman wasn't there back in 2019?
No.
Okay, all right, so when he made the left into the parking lot, and if you have to stand up, you can tell the juror, show the juror what direction he walked.
So we entered the parking lot. He immediately continued around the building to the other side of the parking lot, which is another entrance that leads onto Cleveland Avenue.
Okay. And did you go behind him?
I did.
All right. And what happened once you get to the other side of the Dollar General?
Once we get to the other side, he immediately made the left onto Cleveland. And then we were traveling eastbound on Cleveland towards 75.
And let me ask you, back in 2019, driving southbound, was there any traffic driving southbound back on this date, September 2019?
It was. So it was matter of fact, the light is red, so it was be a picture perfect. There was cars there, so we had to turn it to the general.
Okay. And was there any traffic going northbound or metropolitan?
No.
All right. So once he goes left onto metropolitan, what if anything? I mean, excuse me, left onto Cleveland. What if anything?
Once on Cleveland, the vehicle started picking up speed and continued towards 75.
When the car began picking up speed, what did you do?
I was radio that I had one refusing to stop. Let her copy my traffic, and I proceeded to follow the vehicle.
Okay. And what if anything occurred?
I noticed the vehicle went around traffic into the center lane, and right there it says Cleveland and Forest Hill. He ran the light.
What happened? You just point to?
29Q.
All right, I'll show you 29Q. Okay, so you said that he was going around traffic.
Correct.
Show the general area where he was going around.
You got Forest Hill right there in Cleveland. There's a traffic light right there. And then the light was red and you went around traffic and ran the traffic light.
Okay. So right here at Forest Hill in Cleveland, there's a traffic light at Cleveland?
Mm-hmm.
Is that a yes?
Yes.
Okay, and you said, did the car run that light?
Correct.
All right, and what happened once the car ran the light?
He crossing over 75, still on Cleveland. At this time, I'm approaching Forest Hills at the light. Once I get through the light, I noticed that he was in a vehicle accident.
Okay, and at this one, do you know about how fast y'all were going?
My speed was probably around 45, 40, can't say about how fast he was going, because he had a little bit distance ahead of him.
Okay, and once the accident occurred, what happened?
I noticed that he was already out of the vehicle, and then he was running on foot.
And when he ran on foot, I'm probably gonna do an exercise today.
Okay.
Where did he go?
There's a check cashing place and a cleaners right there at that corner, which there's a fence blocking to keep traffic from running into the buildings and stuff. So he scared the fence, jumped over the fence, and then started running through the parking lot.
Okay. And when you said the check cashing place and the dry cleaners, where approximately on this map is the check cashing place?
It's going to be that first small square building.
Right, in this little block up here?
Yes.
Okay.
And then the cleaner's going to be the little L shape.
All right. So the first small block is the check cashing place. The L shape is the cleaners.
Correct.
There's another gray box. What is that?
That is the admission place.
The admission place. Okay. What direction did he run?
He's running kind of south in between the check cashing place and the cleaners. And then he runs behind the cleaners, in between the cleaners and the admission place.
Okay. And I believe we keep saying a he. Did you recognize the driver to be a man?
Yes.
All right. Now, as he runs through the check cashing place and runs in between the dry cleaner and the admission, what did anything happen?
He started running towards the parking lot, which is 230 Cleveland Avenue, which is that big gray square. Then he enters that parking lot still running. There's a gray sedan, possibly a 7, not for sure, that's parked there. A female is getting out of the car. As the female is getting out of the car, he pushes her out of the way in an attempt to get in the car, but there was another person in the driver's seat.
Did you
I sustain the objection as to, you can rephrase.
Let me ask you, were you observing him running towards the vehicle?
Yes.
And did you observe him trying to go to
I sustain the objection.
I'm sorry, what did you observe?
I observed him pushing the female out of the way to get in the driver's seat. But
That's indirect, so I'll overrule the objection. You may
Did you
finish.
observe him trying to get into the vehicle?
I do.
And did you observe him trying to get into the vehicle after he pushed the lady out of the car?
Not out of the car, but out of the way.
Out of the way.
Yes.
Was he able to get into the car?
No.
What happened?
He continues to take off back running. This time he's running northbound in the parking lot, then he crosses over Cleveland Avenue.
And at this time, are you behind him?
From a distance, yes.
And are you chasing behind him?
I am.
What if anything happens once he crosses Cleveland Avenue?
Once he crosses Cleveland Avenue, I heard something drop, which was later my flashlight. Kind of paused for a second, but he's running in between the Checkers and the other business.
Okay. And time for your exercise again. Where is the Checkers, and approximately where is the Checkers at within this map here?
The Checkers is going to be on the other side of Cleveland where the little T-square is at.
Okay.
And then you got the block building where he runs in between.
All right. And what direction is he running into?
He's running northbound, which leads into another apartment complex.
And where's that apartment complex?
It's 2612 Still Avenue.
Okay. And at this time, do you still have sight of him?
Once he goes behind the Checkers, no, I don't have sight.
All right. And do you actually go over to where, to this side where 2612 Still is?
I did.
And why do you go over there?
To see if he was hiding or laying down somewhere.
All right. And did you see him over there?
No.
All right. Did you eventually learn if he was ever apprehended?
Yes.
And where did you see apprehended?
Right there, the entrance that says Old Hateville and Colony Square.
Okay. And where it says Colonial Square, is that another set of apartments?
It is.
All right. And once the individual was detained, what happened next?
I started, checking, walking back to where they had him detained, and then I came back to where the scene was at.
And let's go ahead and talk about the observation of the accident.
Mm-hmm.
What type of car did the red vehicle hit?
It was a white sedan. I believe it was a Honda.
And did you see anyone inside the white vehicle?
Yes.
Okay. Do you know how many people were inside the white vehicle?
From my knowledge, just us one.
And within the red vehicle, did you see anyone else get out of the red vehicle?
No.
Now, on this thing, did you have body cam video?
I did.
All right. And did your body cam capture, have you been able to review your body cam?
I did.
And has your body cam captured your interaction from what you just testified to a peg road up until you running behind Checkers at 2612 Steel?
Yes.
All right. And back then, tell us what type of uniform you were wearing.
Similar to what I have on without the outer vest.
Without the outer vest?
Yes. So all the equipment that you see up top was on my waist.
Okay.
Except for my camera.
And what was your camera?
Center mass in the middle of the chest.
And did you get out of work at some point in time?
Yes.
Okay. All right. Is that indicated on the video?
Yes.
All right. I'm going to show you what's been marked as Stacy's Exhibit 1Q. Tell me, do you recognize Exhibit 1Q?
Yes.
And how do you recognize Exhibit 1Q?
I have my signature on it along with today's date.
And what's contained within Stacy's Exhibit 1Q?
My body cam footage.
And did that appear to be a fair and accurate depiction of your body cam footage from September 25th, 2019?
It did.
And has there been any addition or deletions to that body cam footage?
No.
Your Honor, this time to state by the Senate Stacy's Exhibit 1Q into evidence.
Any objection, states 1Q. All right, states 1Q is admitted, may be published as you see fit.
And Your Honor, I spoke with Mr. Shaw. We're only going to play the initial portion of the video, which captures what has just been testified.
From when to when?
From 0 to about 4 minutes.
Okay, thank you.
Your Honor,
Sir.
may I clarify for the record? I don't object to the portion that the state is indicating that they will publish. We've had prior conversations.
Okay, thank you, sir.
Yes. Red and color. Roger, speed and your traffic. Speed 40, 45, still on Cleveland. Just 41, just 41. Radio copy, still on Cleveland, 45 miles per hour. How is traffic lighter? Yes. What's your location? 230 Cleveland, 230 Cleveland. 230 Cleveland. Black male, black shirt, black jeans. Black male, black shirt, black jeans. Tempted to 44, tempted to 44. Get down, get down. Tempted to 44. Tempted on right up. Right towards 191. 191 Cleveland. 191 Cleveland. You still have visual? Okay, talk to me. You still have visual? Running towards the apartments. Running towards the apartment. Any unit 59 Wisdom. First unit Wisdom, advise me. What's your location now? 309, what's your location now? Have you made it to the apartment? Where you're raising off your Clydesdale? Yeah, he's back here somewhere. Back in the apartment? Receive 3309, checking on you. 309, you still have visual of the subject? Negative. I lost him back here behind the checkers. Lost sight behind the checkers. You okay? Yeah. Where you copy? Where can you go?
This is Juvederm, a plump that lasts.
I'm glad that the effects last longer, so you don't have to go through it as frequently.
For more important safety information and to find a licensed specialist, visit Juvederm.com.
What we're seeing a little bit past 2612 still. So stop and pausing right here. What area what are we looking at? If we go straight
If you go,
to the steps.
if you go straight up to the steps, there's a fence right here, and then on the other side of the fence is another apartment complex.
And is there a way to get from 2612 Steel to that other apartment complex if you were going to?
Yeah, if you were to run behind this building right here, further up, there's a makeshift cut or path that leads into that other side.
And was the male apprehended? And where was he apprehended?
He was apprehended right at the entrance of that next complex in O'Hagan.
And I'm going to fast forward again just slightly to about 7 minutes. And pausing right here, can you see the general area of the entrance of that second apartment complex?
Yes, ma'am.
Okay, and if you can show the jury where it is, the front part.
The front entrance is right here. There's a gate gated for vehicles to come in. That would be the entrance right there.
And earlier you just talked about the cut. Do you see the cut?
Not on my camera, but it's right up in here.
Okay. All right. Now, what the individual was, the male was detained, was he brought back to where you were?
Yes, ma'am.
And where did you actually go back to?
I went back to the scene of that, where the car was ended up at.
And when the individual was brought back to your location, did you learn who the individual was?
I did.
Okay, and who was the person driving?
Shannon Jackson.
And had you ever met Shannon Jackson before?
No, ma'am.
Had you personally had any interactions with Mr. Jackson before?
No.
Once Mr. Jackson was brought back to where you were, what if anything occurred?
He was saying that he couldn't breathe, stuff like that, so we already requested the ambulance to come out.
And did the ambulance come?
It did.
And did you ever obtain a driver's license from Mr. Jackson?
Not off from Mr. Jackson, but from another officer.
And was it a valid license?
No, ma'am.
And did Mr. Jackson have any belongings on his person?
He had money in his pockets.
And how much money did he have? How much money did you get from him while on duty?
I was saying the officer had counted out $5,000.
And do you know where that money was located on his person?
I believe it was in his front pockets.
Was there any additional money found on Mr. Jackson?
Yes.
Go ahead.
It was roughly $500.
And where did you find that money?
In his front pockets.
And did you find that money while on the scene on Cleveland Avenue or somewhere else?
While we was at Grady Hospital.
And what if anything happened to that $5,500?
I was turned into property.
While on scene, was there anything else done while on scene?
We inventoried the vehicle.
And when you say you inventory the vehicle, which vehicle did you inventory?
That red Nissan.
Okay. And why did you inventory the vehicle?
Because he was in custody.
And what did it was going to happen with the red vehicle?
I didn't impound it, so we had to inventory, see if there were any belongings and values inside the car.
And did you find anything inside the car?
We did.
What did you find?
We found a handgun in the center console.
And what type of gun was found in the center console?
That was a Taurus, I believe, with a 9mm.
And did the gun have a serial number?
It did.
And do you recall the serial number?
Not offhand, but
We're looking at a copy of the police report, help refresh your memory.
yes.
As to the serial number. Permission to approach?
You may, ma'am.
And I'm going to show a copy of his. I'm going to show you what's marked as 36Q. Tell me if you recognize this as 36.
I do.
How do you recognize this as 36Q?
This is my police report.
Is that a very accurate depiction of your police report for this case?
It is.
And we're looking at a copy of your police report, help refresh your memory as to the serial number of the handgun that you found inside of that red Nissan.
Yes.
Have you looked at your report?
Looking for it. Yes.
Okay. And without reading from the page, what was the serial number for the firearm?
9FW03901.
And did you run that serial number on the time?
I did.
And what amazing happened when you ran the serial number on the time?
At the time of the incident, it was showing 905, which means not stolen.
And did you determine if Mr. Jackson should have been in possession of a handgun?
We did.
Okay, and should he have been in possession of a handgun?
No, after doing a criminal history check, we found out he was a convicted felon.
Now, I'm going to show you what's been previously marked and shown to defense counsel as Exhibit 23Q, 24Q, and then 2Q through 21Q. Take a moment, flip them, tell me if you recognize those pictures, those items.
What number?
23, 24 Q. These two, and I think that's that one, 2, 0. Do you recognize for 23 and 24 Q and then 2 through 19 Q?
I do.
And how do you recognize, let's start first with 23 Q and 24 Q.
23Q and 24Q is the vehicle that was struck.
And then looking at 2 Q through 19 Q, how do you recognize 2 Q through 19 Q?
This is the vehicle that he was driving.
And as you continue to go through it.
Okay.
And so this, I'm looking at Stacey's exhibit 19, 20, and 21Q. What's in 19, 20, 21?
That was the firearm that was found in the center console.
And looking at all those pictures, that was the same before, 2 through 21Q and 23 and 24Q. Does that need to be a fair and accurate depiction of the scene on September 25th, 2013?
Yes.
And does it also appear to be a fair and accurate depiction of the weapon found in the car on September 25th, 2019?
Yes, ma'am.
Your Honor, this time it's about September 6th exhibit 2 through 24Q.
Any objection, Mr. Sharp?
No, Your Honor.
All right, states 2 through 19Q and 23 and 24Q are admitted and may be published as you see fit.
And Your Honor, I believe we also had 20 and 21Q as well.
Any further objection to 20 or 21Q, sir? All right, 20Q and 21Q are admitted.
And let me ask you, before we publish these images or some of these images, the lady in the vehicle with the 44, was any information ever received from the lady in the vehicle which called the 44 involved?
No.
Why?
When I got there, she was gone.
Okay.
Her in the car.
They left the area.
Yes.
And in running or chasing, were you able to get the tag number of that vehicle?
No.
So were you able to identify or locate who that individual was?
No.
At this time, we're going to first publish 23. Now, first looking at Stacey Exhibit 23Q, I know we saw some of this in the body cam video, but just orient the jury to where we are within this photograph.
This right here is the off-ramp coming off of 75 northbound onto Cleveland.
And in the distance on the left-hand side, is that a gas station?
It is.
And what is the address of that gas station?
221 Cleveland Avenue.
Far from the distance in the left-hand side, there's a sign. Do you know what that sign is?
That's the Checkers.
And on the right-hand side, are you able in this image to see the red Nissan that you observed Mr. Jackson driving?
Yes.
Okay. And using the stick, I'm sure we can all see, so using the stick, you can point where the red.
The red car is right here.
All right, and I might just have you stand because I might have you show some more. Looking at Stacey Exhibit 24Q. If you're looking at Stacey Exhibit 24Q and you look to the left of the screen, what direction is that on Cleveland Avenue?
If you looking left to the screen, that's going westbound back over on Cleveland, heading towards Metropolitan.
Okay. And do you see that other traffic light going to the left?
Yeah. Right. To the left?
Yes.
Right there?
Yes.
Yeah.
Is that the traffic light at Forest Hill and Cleveland Avenue?
It is.
All right. Now showing Stacey Exhibit 2Q. Is that a closer picture of what we just saw in 23Q?
It is.
Now, looking at the red vehicle, did the red vehicle hit either the tree or the metal frame there?
No, it came to a resting spot. So once it over this sidewalk part, that's where it rested.
All right. And from here, do you see either the dry cleaning or the dry cleaners?
The dry cleaners right here.
All right. Now looking at 3Q. If you can orient, what's the blue building and then that kind of brownish building that has 5?
This is the dry cleaner still, and then right here is be the admission place.
And when Mr. Jackson was running, where was he running in between?
Between the dry cleaners and the admission.
Now looking at Stacey Exhibit 4Q. Is that just another image of the vehicle in front of the vehicle?
Correct.
All right. 5 and 6. Now look at Stacey Exhibit 6Q. Is that the check cash that you've been referencing in your testimony?
It is.
All right. Now, also in your testimony, you said that Mr. Jackson hopped over the fence. Where's the fence in which he hopped over?
This fence right here.
And once he hopped over the fence, is that where he ran in between the buildings?
Once he hopped over the fence, he ran between the cleaners and the check cashing place, and then he cut. You see the admission spot right there.
All right. Looking at 7, we can move forward. Is this all in the picture of the inside of the vehicle?
It is.
All right. Okay. Looking at Exhibit 13Q, what is Exhibit 13Q?
This is the center console. This is the inner lid of the center console.
All right.
And then that's the bottom of the center console where the gun was located.
Okay. And so did you have to lift up the other part to get to where the gun was located?
Yes.
All right. And Is that an image of the gun that was recovered out of the vehicle?
It is.
That's just a close-up. Speaking of that, was the gun loaded?
It was. There's one in the chamber, that's the reason why that was sitting right there.
All right, and did you recall how many was in the magazine?
If you count the one in the chamber, it'll be a total of 8.
It was a total of 8. All right. And is this just a close-up of the type of weapon that it was? Is it just a close-up of the type of weapon?
Yes.
Okay.
The name brand, the serial number, and the caliber.
Okay. And is that the gun is designed with that?
Correct.
All right. And that's a close-up of the bullet,
Yes.
and a close-up of the weapon.
Yes.
All right, you can take it to the floor.
You ready to come? Ready to take it out?
All right, Deputy Ingram is approaching with what has been marked with State Exhibit 22Q. I want you to take a moment and look inside this 22Q and tell me if you recognize what's in State Exhibit 22Q.
This is the weapon that was recovered.
Is that the same picture that we're looking at on 21Q?
It is.
All right, and does that have the same serial number in which, for the gun that we see in the picture of 22?
It does.
Your Honor, this time to say by the tender, State Exhibit 22Q is the evidence.
Any objections, states 22Q, Mr. Sharp?
No, Your Honor.
All right, states 22Q is admitted and may be published as you see fit.
And now permission to publish that. Thank you. No. Thank you, Deputy. Now, I know earlier we talked about the gun being not on file. You said that means that it wasn't stolen. If a gun had been stolen but not reported, would that still come up as not on file?
If a gun's been stolen but not reported, no. It has to be reported stolen for it to be, for you to get the hit on file.
Basis. I'm overrule the objection.
I'm just asking what is not on file. Not on file means not.
Right, at this point, I'll overrule the objection, sir.
Just correct, not on file means that it has not been reported.
Correct.
Did you take out warrants from Mr. Gates?
I did.
What were the warrants or charges that you took out on Mr. Gates?
It would have been fleeing and eluding, reckless driving, no license, not wearing a seatbelt, obstruction of officer, and then possession of a weapon by a convicted felon.
And after being on the scene, did you eventually go down to Brady Hospital?
I did.
All right. And after going down to Brady Hospital, did that include your involvement in this case?
It does.
All right. Court vote. I have no further questions.
Mr. Sharp, why don't we take our break, as I indicated to the jury? You can begin your examination when we come back, okay? All right.
All right, ladies and gentlemen, consistent with the court's other directions, we're going to go ahead and recess. We should be back. If you all could plan on being back for 3:30, and then once all of you have accounted for all of you, we'll bring you back out, and we'll see where the rest of the day leads us. Okay, remember my admonitions that I've given you already, okay? All right, with that, we'll be in recess until about 3:30.
All right, for jury.
In person, not an advocate. What are your thoughts about that?
Yeah, that's absolutely right. Most people, they don't have any connection to a criminal courtroom. So when they go in, they take all of their cues from the judge. And for me, I remember the first time I saw a judge, I was a lot younger and I was like, wow, this judge in his black robe, it's like he's floating. So they look to the judge for, again, they take their cues from the judge and they look to him or her as an authority. So they are very connected to the judge's temperament. And especially as the trial goes on, they understand the legal language a lot more. So he's got a very, very strong influence in this matter.
Yeah, just real quick, I got about 10 seconds. The difficulty with a judge on the spot having to make rulings.
I mean, it's challenging, but again, he's going to get very, very short. He's giving them a lot of leeway. He's saying, hey, rephrase your questions. Now he's going to just straight up going to start overruling a lot of objections or sustain, move on quickly. So they've got to make it work.
Yeah, and that's what you don't want the jury to see you continually not being sustained, because that kind of attitude by the judge can make it look like to the jury that you're wasting their time. Afi, that's it. But everybody stay tuned for our regular scheduled program, where the trial is going to continue to go on. You can find me at RBianchi SQ. Have a great week.
Any objection? Hearing none, 28 and 29Q are admitted and may be published as you see fit.
Thank you, Your Honor. Hey, Your Honor. First of all, that screen is not. Anyone from tech just says Zoom, but it's. Apologize. The witness screen is not on, it just has Zoom, doesn't have.
There's a reason that one's been disabled, so you're gonna have to use the other one.
Okay.
Okay. And he can get up and relocate himself if he'd like to. Okay.
Okay. Thank you. All right. If you can just orient the jury, if you need to stand, you can. To what we are seeing in State's Exhibit 28Q.
Say that again.
If you can orient the jury about the map location is 28.
Yeah, Metropolitan, and you had the Cleveland area.
Okay, and on 28Q, where is Metropolitan?
It is, it runs north and south of Cleveland, where it says 41.
Okay, and when you say 41, this is what we're referencing?
Yes.
All right, and you just referenced Cleveland Avenue, this is what we're discussing?
Correct.
Okay. Now, where was your beat, or where is beat 309?
309 would be.
You can step down if you need to.
Okay. 309 is Cleveland from 75 going westbound. So you would have Metropolitan.
Going this way?
Correct.
All right.
And it would stop right there at Springdale going north.
Okay, so this area, this block here.
Yeah, up to 166.
Up to 166. So this square is 309.
Correct.
All right. And back in 2019, that square was your general beat of 309. Okay. Now, taking you back to September 2019, did you have a certain shift in which you worked?
Yes.
What was your shift?
Evening, which is 2 p.m. to 10 p.m.
And is that your current shift now?
It is.
Have you worked any other shifts while in zone 3 outside of what you did?
No, ma'am.
I want to direct your attention specifically to September 25th, 2019. Were you working that day?
I was.
And were you working the evening shift at this time?
I was.
And where were you? Were you on patrol?
I was.
And where were you on patrol?
That day I was posted up right there at Metropolitan and Peg Road.
And you said Metropolitan Peg, right here?
Correct.
All right. And is there a business location at Metropolitan Peg?
It is. It's a storage facility.
All right. And coming southbound on Metropolitan, Would the facility be on the right-hand side of the street or the left-hand side?
If you come in south, it will be on the right.
All right. And where were you within that facility?
I was sitting right there at the entrance of the parking lot to come into the storage.
And why were you sitting there?
They had several complaints about people breaking into the storage unit, so I was just patrolling that little area.
Okay. And as you were patrolling that area, what if anything happened?
I observed a red sedan traveling southbound on Metropolitan.
And what if anything did you notice when you saw the red sedan traveling southbound on Metropolitan?
I observed the driver dancing around in the driver's seat, and as he passed me, he wasn't wearing a seatbelt.
Okay. And let me ask you this: when you were sitting at the Q Smart, were you facing? Was the front of your car facing Metropolitan?
It was facing in front of Metropolitan.
And do you recall what kind of red vehicle it was?
It was a red Nissan.
All right. And you said you saw the driver dance around.
Correct.
Right. Did you see anyone else from your vantage point at the time inside of you?
There was nobody else in the vehicle.
As you saw the individual dancing around your vehicle, what did you think happened?
Say that again.
What you saw the driver dancing around your vehicle, what did you think happened?
So as soon as he passed me, I noticed that he wasn't wearing a seatbelt, so I immediately got out in the traffic to get behind the vehicle.
And what happened once you got behind it?
Once we approached the intersection of Metropolitan and Cleveland, I activated my emergency lights to get the driver to pull over.
And did the driver pull over?
He turned on his left signal to turn into the Dollar General parking lot.
And where's the Dollar General parking lot?
It sits on the corner, east corner of Metropolitan and Cleveland.
All right, looking back at our map, where is the general vicinity where the Dollar General will be?
It will be right up here.
Right here?
Yes.
Okay. And what happened once the vehicle turned to the Dollar General?
As soon as he entered the parking lot, he immediately continued to the other side of the parking lot, back out onto Cleveland.
I'm going to show you what's been marked as 6035Q, which should be picture 3. Do you recognize what the 6035Q?
I do.
How do you recognize what the 6035Q?
That's the Dollar General right at the corner of Metropolitan and Cleveland.
Is that the same Dollar General that we just referenced on the map?
It is.
And is that a fair and accurate depiction of the Dollar General back in 2019?
It is.
Your Honor, this sounds like 10 to 6035Q.
Interjection, states 35Q.
Okay.
All right, states 35Q is admitted and may be published as you see fit.
Okay. For the jury, this is Dollar General that we've just been speaking of. That's Dollar General?
It is.
And if you can just orient the jury right now to what we're seeing, where's the intersection, and what we're seeing in 6035Q.
The intersection is right there where the red light is at. So that's the main street you're looking at, that's Metropolitan. Then where the red light is at, that's Cleveland. And then he enters the parking lot right there where the gentleman is walking across at the entrance of Metropolitan to the Dollar General.
And is it fair to say that that gentleman wasn't there back in 2019?
No.
Okay. All right. So when he made the left to the parking lot, if you have to stand up, you can tell the jury, show the jury what direction he walked.
So we entered the parking lot. He immediately continued around the building to the other side of the parking lot, which is another entrance that leads onto Cleveland Avenue.
Okay. And did you go behind him?
I did.
All right. And what happened once you get to the other side of the Dollar General?
Once we get to the other side, he immediately made the left onto Cleveland. And then we were traveling eastbound on Cleveland towards 75.
And let me ask you, back in 2019, driving southbound, was there any traffic driving southbound back on this day, September 2019?
It was a matter of fact, the light is red, so it was be a picture perfect. There was cars there, so he had to turn into the Dollar General.
Okay. And was there any traffic going northbound on Metropolitan?
No.
All right. So once he goes left onto Metropolitan, what if anything? I mean, excuse me, left onto Cleveland, what if anything?
Once on Cleveland, the vehicle started picking up speed and continued towards 75.
When the car began picking up speed, what did they do?
I advised radio that I had one refusing to stop. Let her copy my traffic, and I proceed to follow the vehicle.
Okay. And what, if anything, occurred?
I noticed the vehicle went around traffic into the center lane, and right there where it says Cleveland and Forest Hill, he ran the light.
What happened? You just point to?
29Q.
All right, show you 29Q. Okay, so you said that he was going around traffic.
Correct.
Show the general area where he was going around.
I got Forest Hill right there in Cleveland. There's a traffic light right there. And then the light was red and he went around traffic, ran the traffic light.
Okay. So right here at Forest Hill in Cleveland, there's a traffic light at Cleveland?
Mm-hmm.
Is that a yes?
Yes.
Okay, and you said, did the car run that light?
Correct.
All right, and what happened once the car ran the light?
He crossing over 75, still on Cleveland. At this time, I'm approaching Forest Hills at the light. Once I get through the light, I noticed that he was in a vehicle accident.
Okay, and at this one, do you know about how fast y'all were going?
My speed was probably around 45, 40. Can't say about how fast he was going, because he had a little bit distance ahead of him.
Okay. And once the accident occurred, what happened?
I noticed that he was already out of the vehicle, and then he was running on foot.
And when he ran on foot, I'm probably gonna do exercise today.
Okay.
Where did he go?
There's a check cashing place and a cleaners right there at that corner, which there's a fence blocking to keep traffic from running into the buildings and stuff. So he scaled the fence, jumped over the fence, and then started running through the parking lot.
Okay, and when you said the check cashing place and the dry cleaners, where approximately on this map is the check cashing place?
It's going to be that first small square building.
Right, in this little block up here?
Yes.
Okay.
And then the cleaner's going to be the little L shape.
All right, so the first small block is the check cashing place, the L shape is the cleaners.
Correct.
There's another gray box, what is that?
That is the admission place.
The admissions place, okay. What direction did he run?
He's running kind of south in between the check cashing place and the cleaners. And then he runs behind the cleaners, in between the cleaners and the admission place.
Okay, and I believe we keep saying that did you recognize the driver to be a male?
Yes.
All right. Now, as he runs through the check cashing place and runs in between the dry cleaners and the admission, what did he have?
He started running towards the parking lot, which is 230 Cleveland Avenue, which is that big gray square. He enters that parking lot still running. There's a gray sedan, possibly a 7, not for sure, that's parked there. Female's getting out of the car. As the female's getting out of the car, he pushes her out of the way in an attempt to get in the car, but there was another person in the driver's seat.
I sustain the objection. You can rephrase.
Let me ask you, were you observing him running towards the vehicle?
Yes.
And did you observe him trying to go beyond the vehicle?
I sustain the objection.
What did you observe?
I observed him pushing the female out of the way to get in the driver's seat, but
That's direct, so I'll overrule the objection. You may finish.
Did you observe him trying to get into the vehicle?
I did.
Did you observe him trying to get into the vehicle after he pushed the lady out of the car?
Not out of the car, but out of the way. Yes.
Was he able to get into the car?
No.
What happened?
He continues to take off back running. This time he's running northbound in the parking lot, and then he crosses over Cleveland Avenue.
And at this time, are you behind him?
From a distance, yes.
And are you chasing behind him?
I am.
What if anything happens once he crosses Cleveland Avenue?
Once he crosses Cleveland Avenue, I heard something drop, which was later my flashlight. I kind of paused for a second, but he's running in between the Checkers and the other business.
And copy the exercise again. where is the checkers and approximately where is the checkers at within this map here?
The checkers is going to be on the other side of Cleveland where the little T square is at.
Okay.
And then you got the block building where he runs in between.
All right. And what direction is he running into?
He's running northbound, which leads into another apartment complex.
And where's that apartment complex?
2612 Still Avenue.
Okay. And at this time, do you still have sight of him?
Once he goes behind the checkers, no, I don't have sight.
All right. And do you actually go over to where, to this side where 2612 Steel is?
I did.
And why do you go over there?
To see if he was hiding or laying down somewhere.
All right. And did you see him over there?
No.
All right. Did you eventually learn if he was ever apprehended?
Yes.
And where did you see apprehended?
Right there, the entrance where it says Old Hateville and Conley Square.
And where it says Colonial Square, is that another set of apartments?
It is.
And once the individual was detained, what happened next?
I started, checking, walking back to where they had him detained, and then I came back to where the scene was at. And
let's go back and talk about the observation of the accident.
mm-hmm.
What type of car did the red vehicle hit?
It was a white sedan. I believe it was a Honda.
And did you see anyone inside the white vehicle?
Yes.
Okay. Do you know how many people were inside the white vehicle?
From my knowledge, just us one.
And within the red vehicle, did you see anyone else get out of the red vehicle?
No.
Now, on this day, did you have body cam?
I did.
All right. And did your body cam capture, have you been able to review your body cam?
I did.
And has your body cam captured your interaction from what you just testified to on Peg Road up until you running behind checkers at 2612 Steel?
Yes.
All right. And back then, tell us what type of uniform you were wearing.
Similar to what I have on without the outer vest.
Without the outer vest?
Yes. So all the equipment that you see up top was on my waist.
Okay.
Except for my camera.
And where was your camera?
Center mass in the middle of the chest.
And did you get out of work at some point in time?
Yes.
Okay. All right. And is that indicated on the video?
Yes.
All right. I'm going to show you what's been marked as State's Exhibit 1Q. Tell me if you recognize Exhibit 1Q.
Yes.
And how do you recognize Exhibit 1Q?
It has my signature on it along with today's date.
And what was on and what's contained within State's Exhibit 1Q?
My body cam footage.
And did that appear to be a fair and accurate depiction of your body cam footage from September 25th, 2019?
It did.
And has there been any additions or deletions to that body cam footage?
No.
Your Honor, this time the state by the Senate State's Exhibit 1Q into evidence.
Any objection to States 1Q? All right, States 1Q is admitted, may be published as you see fit.
And Your Honor, I spoke with Mr. Shaw. We're only going to play the initial portion of the video which captures as just been testified.
From when to when?
From 0 to about 4 minutes.
Okay, thank you.
Your Honor.
Sir.
Can I clarify for the record? I don't object to the portion that the state is that they will publish. We've had prior conversation.
Okay.
Red in color, red in color. Speeds 45, still on Cleveland. Just 41, just 41. Radio copy, still on Cleveland, 45 miles per hour. How is traffic later? Cleveland, 230 Cleveland. 230 Cleveland. Black male, plaid shirt, black jeans. Black male, black shirt, black jeans. Tempted to 44, tempted to 44. Get down, get down. Copy, tempted to 44. 59 right up. Right towards 191. 191 Cleveland. 191 Cleveland. You have visual? Okay, talk to me. You still have visual? Running towards the apartments. Running towards the apartment. Any unit 59 Woodson. First unit Woodson, advise me. What's your location now? 309, what's your location now? Have you made it to the apartment? Are you raising off your pod still? Yeah, he's back here somewhere. Back in the apartment? Checking on you. 309, you still have visual to touch it? Negative. I lost you back here behind the checkers. Lost sight behind the checkers. You okay? Yeah. Where you copy? Where can you go? Trying to have a very reasonable perimeter where we went. One unit to route 309 location advised that you are set up a perimeter in the area of 1 Seat Avenue. Breakdown resumed. 305, 42, I spent one thing in the area. 2343 radio copy, getting the subject time. James 4 Zone 3, you got checkers on Cleveland. I moved everybody to making the subject detained. 3309, was it just one person or more?
I thought it said five minutes. Stop. They did not read 5 minutes and 10 seconds. There's a few things that were shouted in the video. One, what's a 41?
Accident.
Accident?
Mm-hmm.
And then what's a 42?
It's a robbery.
And in looking first, what we have depicted on the screen right here, there's broken sticks.
Mm-hmm.
So we're gonna use that.
Okay.
What are we looking at here? Is this an apartment complex?
Yeah, this apartment this is the backside, or you saw when you walked through the cut, but this is 2612 Still Avenue.
And on the other side of 2612 Still, I'm just gonna fast forward slightly to about 6 minutes, about 7 minutes. I'm tell you what we're seeing a little bit past 2612 Still. So stop pausing right here. What area? What are we looking at? We go straight.
If you go straight up to the steps, there's a fence right here, and then on the other side of the fence is another apartment complex.
And is there a way to get from 2612 Steel to that other apartment complex if you were going to?
Yeah, if you were to run behind this building right here, further up, there's a makeshift cut or path that leads into that other side.
And was the male apprehended? And where was he apprehended?
He was apprehended right at the entrance of that next complex in O'Hayville.
I'm going to
Yes, ma'am.
Okay, you can show the jury where is front part.
The front entrance is right here. There's a gate gated for vehicles to come in. That would be the entrance right there.
And then earlier you talked about the cut. Do you see the cut?
Not on my camera, but it's right up here.
All right. Now, once the individual was, the man was detained, was he brought back to where you were?
Yes, ma'am.
And where did you actually go back?
I went back to the scene of that, where the car was ended up at.
And when the individual was brought back to your location, did you learn who the individual was?
I did.
Okay, well, who was the person dropped?
Shannon Jackson.
And had you ever met Shannon Jackson before?
No, ma'am.
Had you personally had any interactions?
No.
Once Mr. Jackson was brought back to where you were, what happened?
He was saying that he couldn't breathe, stuff like that. So we already requested the ambulance to come out.
And did the ambulance come?
They did.
And did you ever obtain a driver's license from Mr. Jackson?
Not off of Mr. Jackson, but from another officer.
And was it a valid license?
No, ma'am.
And did Mr. Jackson have any belongings on his person?
He had money in his pockets.
And how much money did he have? How much money did you get from him while
On scene, the officer had counted out $5,000.
And do you know where that money was located on his person?
I believe it was in his front pockets.
Was there any additional money found on Mr. Jackson?
Yes. It was roughly $500.
And where did you find that money?
In his front pockets.
And did you find that money while on the scene on Cleveland Avenue or somewhere else?
While we was at Grady Hospital.
And what if anything happened to that $5,500?
I was turned into property.
While on scene, was there anything else done while on scene?
We inventoried the vehicle,
And we take inventory of the vehicle. Which vehicle did you take?
the red Nissan,
And why did you have to inventory the vehicle?
because he was in custody.
And what if it was going to happen with the red vehicle?
I was being impounded, so we had to inventory, see if there any belongings and values inside the car.
And did you find anything inside the car?
We did.
What did you find?
We found a handgun in the center console.
And what type of gun was found in the center console?
It was a Taurus, I believe, with a 9mm.
And did the gun have a serial number?
It did.
And you recall the serial number?
Not offhand, but
We're looking at a copy of the police report, how refresh your memory.
yes.
As to the serial number. Permission to approach?
You may, ma'am.
And I'm going to show a copy of this. I'm going to show you what's marked as 36Q. Tell me if you recognize this as 36.
I do.
How do you recognize this as 36?
This is my police report.
Is that a fair and accurate depiction of your police report for this case?
It is.
And we're looking at a copy of your police report, help refresh your memory as to the serial number of the handgun that you found inside of that red Nissan.
Yes.
Have you looked at your report?
I'm looking for it. Yes.
Okay. And without reading from the page, what was the serial number for the firearm?
9FW03901.
And did you run that serial number on the time?
I did.
And what made you have when you ran the serial number on the time?
At the time of the incident, was showing not on file, which means not stolen.
And did you determine
We did.
And should he have been in possession?
No, after doing a criminal history check, we found out he was a convicted felon.
Now, I'm going to show you what's been previously marked and shown to defense counsel, State Exhibit 23Q, 24Q, and then 2Q through 21Q. Take a moment, flip and come and recognize. Go by them.
What number?
23, 24, too. Do you recognize from 23 to 24 Q and then 2 to 19?
I do.
And how do you recognize, let's start first with 23 Q and
23Q and 24Q is the vehicle that was struck.
And then looking at 2Q to 19Q, how do you recognize 2Q to 19Q?
This is the vehicle that he was driving.
And as you can see, the both were.
Okay.
And so this, I'm looking at Stacy Exhibit 19, 20, and 21Q. What's in 19, 20, 21?
That was the firearm that was found in the center console.
And looking at all those pictures that was prepared before, 2 through 21Q and 23 and 24Q. Does there need to be a fair and accurate depiction of the scene on September 25th, 2013?
Yes.
Does it also appear to be a fair and accurate depiction of the weapon found in the car on September 25th, 2019?
Yes, ma'am.
All right, this time it's like 10 to 6 exhibit, really 2 through 24Q.
Any objection, Mr. Sharp?
No, Your Honor.
All right, states 2 through 19Q and 23 and 24Q are admitted and may be published as you see fit.
And I believe we also had 23 and 21Q as well.
All right. Any further objection to 20 or 21Q, sir? All right, 20Q and 21Q were admitted.
And let me actually, before we publish these images, some of these images, the lady in the vehicle with the 44, was any information ever received from the lady in the vehicle which called the 44
No, ma'am.
Why?
When I got there, she was gone.
Okay.
Her in the car.
Still not there.
Yeah.
And in running or chasing, had you gotten, were you able to get the tag number of that vehicle?
No.
So were you able to identify who that individual was?
No, ma'am.
At this time, we're going to first publish 23. Now, first looking at Stacy Exhibit 23Q, I know we saw some of this in the body cam video, but the jury to where we are within this program.
This right here is the off ramp coming off of 75 northbound onto Cleveland.
And in the distance on the left-hand side, is that a gas station?
It is.
And what is the address of that gas station?
221 Cleveland Avenue.
Far on the distance on the left-hand side, there's a sign. Do you know what that sign is?
That's the checkers.
And on the right-hand side, do we see, are you able in this image to see the red Nissan that you observed Mr. Jackson driving?
Yes.
And using the stick, we can see the new stick, you can point where the red.
The red car is right here.
All right, and I might just have you stand because I might have you just looking at this, there was 24 Q. If you're looking at this, there was 24 Q, and you look to the left of the screen, what direction is that on Cleveland Avenue?
If you looking left to the screen, that's going westbound back over on Cleveland, heading towards Metropolitan.
And do you see that other traffic light? Go to the left?
Yeah. Right. Oh, to the left?
Yes.
Right there?
Yes.
Yeah.
Is that the traffic light at Forest Hills?
It is.
All right. Now show you 672 Q. Is that a closer picture of what we just saw in 23 Q?
It is.
Now, looking at the red vehicle, did the red vehicle hit either the tree or the metal frame there?
No, it came to a resting spot. So once it over this sidewalk part, that's where it rested.
All right. And from here, do you see either the dry cleaning or the dry cleaners?
The dry cleaners right here.
All right. Now look at 3Q. If you can orient, what's the blue building and then that kind of brown building that has?
This is the dry cleaner still, and then right here is be the mission place.
And when Mr. Jackson was running, where was he running in the
It is.
All right. Now showing State's Exhibit 2Q. Is that a closer picture of what we just saw in 23Q?
It is.
Now, looking at the red vehicle, did the red vehicle hit either the tree or the metal frame there?
No, it came to a resting spot. So once it over this sidewalk part, that's where it rested.
All right. And from here, do you see either the dry cleaning or the dry cleaners?
The dry cleaners right here.
All right. Now looking at 3Q. If you can orient, what's the blue building and then that kind of brown building that has?
This is the dry cleaner still, and then right here is be the mission place.
And when Mr. Jackson was running, where was he running in between?
Between the dry cleaners and the mission.
Now looking at State's Exhibit 4Q. That's just another image of the vehicle what it's probably looking for.
Correct.
All right. 5 and 6. Now look at State's Exhibit 6Q. That the check cashing that you've been referencing in your testimony.
It is.
All right. Now also in your testimony you said that Mr. Jackson hopped over the fence. Where's the fence in which he hopped over?
This fence right here.
And once he hopped over the fence, is that where he ran in between them?
Once he hopped over the fence, he ran between the cleaners and the check cashing place, and then he cut. You see the mission spot right here.
Looking at 7, we move forward. This is all the picture of the inside of the vehicle.
It is.
Looking at Exhibit 13Q, what is Exhibit 13Q?
This is the center console. This is the inner lid of the center console.
All right.
And then that's the bottom of the center console where the gun's located.
And so did you have to lift up the other parts to get to where the gun was located?
Yes.
All right. And is that an image of the gun that was recovered out of the vehicle?
It is.
Just a close up. Speaking of that, was the gun loaded?
It was. There was one in the chamber, that's the reason why that sitting right there.
All right. And did you recall how many was in the magazine?
If you count the one in the chamber, it'll be a total of 8.
Okay. All right. That's a close up of the type of weapon that it was. There's a close up of the type of weapon.
Yes.
Okay.
The name brand, the serial number, and the caliber.
And it's that the gun is inside of the box.
Correct.
And that's a close up of the bullet,
Yes.
Close up of the weapon.
Yes.
All right. You can take it forward.
You ready to come? Ready to take it up?
All right. Deputy Ingram is approaching with what has been marked as Exhibit 22Q. I want you to take a moment and look inside of this 22Q and tell me if you recognize what's in Exhibit 22Q.
This is the weapon that was recovered.
It is that same picture that we're looking at on 21Q.
It is.
All right. And does it have the same serial number in which for the gun that we see the picture of 22Q?
It does.
Your Honor, this time seems like the tender seems to be 22Q with that.
Any objections, states 22Q, Mr. Sharp? All right, states 22Q is admitted and may be published as you see fit.
You said that means that it wasn't stolen. If a gun had been stolen but not reported, would that still come up as not on file?
If a gun's been stolen but not reported, no. It'll have to be reported stolen for it to be, for you to get a hit on file.
Basis, what's the? I'm overrule the objection.
I'm just asking what is not on file. Not on file means not.
Right, at this point, I'll overrule the objection, sir.
Just that not on file means that it has not been reported.
Correct.
Did you eventually take out warrants from Mr. Gates?
I did.
What were the warrants or the charges that you took out?
It would have been fleeing and eluding, reckless driving, no license, not wearing a seatbelt, obstruction of officer, and then possession of a weapon by a convicted felon.
And after being on the scene, did you eventually go down to Brady Hospital?
I did.
And after going down to Brady Hospital, did that include your involvement in this case?
It does.
I have no further questions.
Whatever you do it for less at Harbor Freight.
Good morning, Mr. Hutchins. How are you?
Good.
And Happy New Year to you.
Thank you. Mr. Hutchins, do me a favor. I want you to yell in that microphone, okay? So we can all hear you, all right? Or I'll put it this way, use your outside voice. Let's see how that goes. Can we do a test? Test. All right, okay. Just try and keep that level up if you wouldn't mind for us, okay? All right. All right, thank you, sir.
And Mr. Hutchins, where are you from?
Atlanta, Georgia.
All right. And do you currently reside within the metro Atlanta area?
No, I live in Loganville.
And how long have you been in Loganville?
Well, like a year and a half.
You said a year and a half? And are you currently working?
No,
Why aren't you working?
because I had a stroke.
How long ago did you have your stroke?
Back when COVID started, 2020.
And with you having a stroke, has it affected your memory at all?
Yes.
Now, let me ask you, prior to having a stroke, did you work?
Yes.
What type of work did you do?
Security.
And how long were you in the security industry?
Give or take about 25 years.
25 years. And while in the security industry, did you ever work for Velour Security Services?
Yes, I have.
And if you can recall, approximately when did you work for Velour Security Services?
About from 2013 to 2015.
And when you worked for Velour Security Services between 2013 and 2015, did you have a particular location that you were responsible for securing?
We secured the whole mall.
And when you say the whole mall, which mall are you referring to?
Perimeter Mall.
And did you work at Perimeter Mall for that entirety of that 2013 to 2015 period?
Yes.
When you worked at Perimeter Mall, what were some of your job duties and responsibilities?
To help out people to go to accident scenes, wherever they may be.
You said to go to accident scenes? If you shook your head, is that a yes?
Yes.
And is that accident scenes within the mall?
Yes.
Did you ever have the responsibility for patrolling outside of the mall as well?
Yes.
Within Perimeter Mall, was there a particular unit or area where the security team was housed if you weren't patrolling? Did you have an office area?
Yes.
And in that office area, was that a shared space or did you have your own individual office within the security office area?
All of the officers shared that area.
And was that area a secured area?
Yes.
And just generally, if there was an incident that occurred at the mall, say an accident or anything like that, would you have to make an incident report, an internal incident report?
Yes.
And generally, when there was, say, an accident at the mall, did you always have to call outside law enforcement, or was that only on certain occasions?
No. It was only a certain occasion.
Why would you have to call law enforcement out?
If somebody slipped and fell and hurt themselves, well, catalytic converters, things of that nature.
And when we say catalytic converters, what do you mean?
They were cutting them off.
They were cutting them off at the mall.
Yes.
Like people would come up and cut off people's catalytic converters.
Yes.
If there were any crimes like theft, would you have to call the police?
I would have to call in person.
Who would have to call?
Mr. May.
Mr. May. And who is Mr. May?
He's director of security.
He's director of security. And was Mr. May your director of security the entire 2 years that you were at Perimeter Mall?
Yes.
As your supervisor, what was some of his responsibilities? As Mr. May, he was your supervisor?
He was over the whole department.
And do you know, as his job over the entire department, some of his responsibilities?
No.
All right, Deputy, can you check and see if all our jurors are in pocket, please, sir? Hold on. Can I get you to step outside for me just a second, please? Okay, Officer Cogdale's not here, and jury's not, is also absent. Mr. Sharp, what do I need to take up?
Your Honor, there's two matters. The state during the break has indicated you will show me some what appear to be certified convictions. My client had indicated that I don't know if it's going to be later today or tomorrow, but sometime in the near future.
Wait. Can you all go back, please? Thank you. Okay, so you said these certified convictions?
Right, that they're going to seek to introduce into evidence. And
okay, and they have shown those to you?
They have, and there's four. Two of them, I believe, relate to overt acts or alleged overt acts in this indictment. My issue, other than some extraneous pages included in the certifieds, my issue is not with the admission of those subject to our prior kind of blanket Bruce Harvey rule objections. However, two additional convictions, there's one from 2010 and I believe 2011, are not listed as overt acts in the indictment. The state's stance, I believe, is that they are listed in the overt act itself, overt act 98. If you look at it, my client is alleged to have committed possession of firearm by a convicted felon, and then the state in the pleading lists 4 separate felonies that they're alleging my client, that make my client a convicted felon. That
doesn't make sense. I mean,
that does, because you only need one.
You only need one, okay, but
right. And so they've listed 4, and now they're seeking to introduce certified of 4 separate extraneous convictions that, again, I'm acknowledging that 2 of them are overt acts in this case, and that's not my issue.
You don't have the objection to those.
There's some extra paperwork in there that I can specify what I object to.
Well, you know that when, let's assume that I admit them, okay, if they're in proper form. Before they go to a jury, There's some of the things that will be stripped out because they would violate the continuing witness rule and some other things.
I understand. And
so we'll get to that later, but
I do object to the two that are not listed as overt acts because
the ones in
it violates
2010 and 2011.
I don't have them in front of me. The state has them. I believe I know one of them is 2010. One's a burglary, and then one is a theft and a gang charge. Ironically, charging a separate gang, but those should not be admitted into evidence. And I'm relying on Old Chief United States 519.
Old Chief?
Yes.
Oh.
519.
You found anything more recent?
U.S. v. Marroquin, M-A-R-R-O. U.S. v. Marroquin, M-A-R-R-O-Q-U-I-N, Lopez, 634 Federal Appendix 758, that's 2015, but it discusses Old Chief. Old Chief's still good law, and it basically, Judge, it comes down to 403. I mean, I don't think anyone that's been watching this trial, anyone that heard my opening would suggest that that the issue of whether Mr. Stilwell is a convicted felon is really at issue. It's not at issue. It never has been an issue. I said it in opening.
Well, they still got to prove it. They still got to prove
it. And they can with a prior, but they don't need to prove it with 4. And the prejudicial value substantially outweighs the probative value when things do not have probative value. And so if you look at the indictment Act 98, they list 4 prior felonies: participation in criminal street gang activity from May 2010, which is indictment 11 SC 98860. I object to that. They list a burglary from June 2nd of 2011, indictment 13 SC 121320. I object to that. Then they also list possession of marijuana with intent to distribute from September 19th, 2013, which is 15 SC 140132. We've heard testimony about that. And my client pled guilty to that, and we understand that that is listed as an overt act. So we're not going to specifically complain about the admission of that one. And the other one is possession of marijuana with intent to distribute, possession of firearm by a convicted felon from March 10th, 2016, which is 15 SC 140132. And I don't object to that. The other one I don't object to, I'm sorry, I read it wrong, Your Honor, it's 13 SC 121320. The ones I object to are 11 SC 98860 and 10 SC 87662.
Okay, well, they pled them specifically in the act, and that's Act 98, right?
Correct.
Okay, so I mean, if they're in proper form, wouldn't they go to an element? I mean, they go to an element of proof.
No, we could easily redact this indictment. We did it with count 25, I believe it was, on this indictment.
That was for another ground, though.
Well, it is, but I mean, it can be done. And the bottom line is, all of this still needs to pass Rule 403. Just because the state puts it on a piece of paper doesn't mean 403 doesn't apply.
I understand. Okay. Well, if I understand your objection, are you saying that the court needs to apply the 403 balancing test? I mean,
yeah, as discussed in the Old Chief case and the other case that I cited, and many other cases, Your Honor, and also. I'll just point out the prejudicial value. The prejudicial value of these priors that are not listed as overt acts, specifically 10 SC 87662, is particularly great based on the charge being participation in criminal street gang.
All right. What's the state's position on that?
Your Honor, the state's position.
Can I see the convictions to begin with? Do you have them? You have them?
Yes.
Okay.
And just for clarity, for the purposes of the record, Judge, we have labeled State's Exhibit 31Q
Hold on a second. Said 31Q, and which one's this one now?
This is the certified for 10SC A7662, Your Honor, which is a part of the allegation in not only count 98, but count 55 as well, as we discussed with Mr. Sharp prior to speaking with the court.
Okay, what's the next one?
The next one is 32Q, which is the certified conviction for 11SC 98860, which too is listed in both Acts 55 and Acts 98.
Okay.
We then have States 33Q, which is a certified conviction for 13SC 121320.
So 13SC, what was that? I'm sorry.
121320.
121130?
No, Your Honor.
I'm sorry.
13SC 121320.
Thank you.
You're welcome.
And what does that go to? Counts what?
And that too is listed in Acts 55 and Acts 98.
Okay.
And we also intend to introduce States 30Q, which is the certified conviction for 19 SC 173371, which is the act itself that is alleged in Act 98. Part of the act. And I will present them at the court's pleasure whenever the court tells me to present them, to approach and present.
Okay, have you seen them, Mr. Sharp?
I have.
Can you
Yes.
approach, let me look. Hand it to Mr. Kearns, please, so I can look at it.
Yes. And Your Honor, in reviewing them with Mr. Sharp, there are some sticky notes on there just to mark certain areas he wanted us to be mindful of.
All right.
That had no bearing on the fighting of.
Your Honor, may I add one thing to my argument? Well, actually two.
We discussed something, we haven't.
Hold on one second, sir.
Okay.
Mr. Shaw, I'll let you know when I'm ready, okay?
Okay. Thank you, Judge.
Okay, all right.
They're doing the entire page. I want to see it. And come on, man.
Time just one second, okay? All right, go ahead. As soon as he finishes.
Your Honor, I was going to add two other things. I just wanted to call your attention to the fact that both of these convictions that I'm arguing against are alleged to have occurred prior to the alleged RICO conspiracy. But also, most importantly, Your Honor, we shouldn't have to because we've basically done it in the opening, but we're willing to stipulate to my client's convicted felon status if that clears anything up. I mean, I don't think, again, from watching this case, I don't think that's an issue at all. And they have at least two prior felonies that seem to make that pretty clear. And we're not arguing that it's not clear, but we'll stipulate to it. in fact, but we just don't think it's appropriate just because the state throws things into the indictment to bring in bad character evidence against my client.
I don't think it's bad character. It's and they're not doing it for that particular reason.
Well, what is, I mean, I just don't understand what the reason is, because the only legitimate reason is to prove he's a convicted felon, and he clearly is. So.
Well, I'll let the state respond to that. Is that the two bases?
Yes, we're willing to sit.
Okay, all right. Yes, Ms. Lowe.
Thank you, Judge. Your Honor, what it seems that Mr. Sharp is doing is asking for essentially a striking of the indictment, something that should have been dealt with pre-trial, because where we are now in Act 55 and Act 98, these are portions of the act that the state alleges, so they constitute proof of what we've alleged in the indictment. As to the argument regarding 403 and a 403 analysis, these allegations are not allegations that, or the certified convictions rather, are not convictions for the types of crimes that are substantially more prejudicial than probative as they relate to Mr. Sharp's client. The fact that he now asserts that these crimes happened prior to the beginning of the alleged conspiracy is of no consequence, especially where it's these acts that have occurred are in fact kind of integral to other evidence that will be presented at trial. Mr. Stillwell, in that 10 SC 87662, committed those acts as part of the criminal street gang that we do reference in this indictment. We talk about 30D, we talk about not just YSL. Mr. Stillwell, in one of the songs or lyrics that may be talked about, there's a reference to the Blue Jean Bandits, there's a reference to 30D, and this is just ancillary, but this gang charge that is alleged in 10 SC 87662 is in fact one of those kind of incidents where she was alleged to have and actually was convicted of gang activity for that type of act on his part, along with others. But that aside, Your Honor, the bare fact is that the state has alleged in Act 55 and Act 98 that Mr. Stillwell had been convicted of these offenses, and the state has the right to prove up its indictment in the way that the state sees fit. This is not one of those circumstances where the convictions in any way prejudice Mr. Stillwell, and certainly they don't substantially prejudice him in a way that makes the admission of these convictions more prejudicial, substantially more prejudicial than probative. He's essentially trying to dictate the way that the state proves up its case, and the defendant doesn't have the right to do that. The state has the right to prove up its case in the most effective and impactful way that we are legally allowed to do. And given that we have made these allegations, that this indictment has been read to the jury, and that we have bona fide certified copies of these convictions, the state should be allowed to introduce that evidence to the jury, and should not be kept from doing so for reasons that are not, there's no reason to keep the state from doing so. The defendant just does not get to dictate how the state proves up its case. So we are just asking that the court deny these motions to keep out evidence of acts that have been alleged in our indictment.
And Your Honor, they keep saying I don't get to dictate how they try their case, and I acknowledge generally that's true, but that's the whole holding of Old Chief, is just because they allege it in the indictment doesn't mean they get to just let everything in, no matter how prejudicial it is, no matter how limited the probative value is. That's the whole point of Old Chief.
Old Chief is a little different. Old Chief, this is Old Chief versus US, 519 US 172. A little different aspect. I see what you're saying about Old Chief in terms of you're willing to stipulate that particular issue in terms of the convicted felon issue, which Old Chief was a singular issue, and that's part of why the Supreme Court dealt with it in the manner that they did. The state is alleging, however, that given the other elements of proof that they're alleging, in particular Acts 55 and 98, 55 being the defendant from the incident involving 7/15/2015, defendant Shannon Silver, associated with YSL, did commit the felony offense of possession of a firearm by a convicted felon in violation of Georgia law pursuant to OCGA 1611-131 by possessing a firearm, to wit, a handgun, after being convicted of felony in indictment 10 SC 87662 in the Superior Court of Fulton County for the offense of participation in criminal street gang activity and burglary on the 26th day of May 2010 in indictment 11 SC 98860 in the Superior Court of Fulton County for the offense of burglary on the 2nd day of June 2011 in indictment 13 SC 121320 in the Superior Court of Fulton County, Georgia for the offense of possession of marijuana with the intent to distribute on the 19th day of September 2013, an overt act in furtherance of conspiracy. So, and then in addition, in Act 98, they allege similarly participation in criminal street gang activity and these acts in furtherance of overt acts and furtherance of conspiracy. I know it may, and looking at it from a 403 perspective, Mr. Sharp, and of course, in looking at Old Chief and looking at what the measure of prejudice is, evidence is unfairly prejudicial when it would influence a jury to decide the case on an improper basis, and courts have noted that there's a difference between evidence that is simply prejudicial and in that it hurts a party's case admissible, and evidence is unfairly prejudicial, which is inadmissible. So the 11th Circuit, in looking at this particular issue, in the United States versus Patrick, that's 513 F APPX 882, 11th Circuit 2013. While invoking the exclusionary elements of 403, in addition to cautioning that the rules should be used sparingly, the 11th Circuit Court of Appeals looks at the evidence in light most favorable to its admission, maximizing its probative value and minimizing its undue prejudicial impact. Consistent with this authority, courts have noted that the key term in 403 is not prejudicial, but unduly. So in this particular circumstance, I don't believe that these particular convictions, now there are some things in there that will need to be discussed and paired out before actually being handed to a jury, but I don't believe that this is going to lead to confusion of the issues, mislead the jury, be a waste of time, unduly delay, or needlessly present cumulative evidence. So applying a 403 analysis, I believe these convictions, if in proper form, would be admissible to prove the state's case, or attempt to prove, I should say, because that's a jury's issue, whether or not they proven to a satisfactory extent Acts 55 and 98.
Well, Your Honor, just briefly, if I can respond, the proof, it is cumulative.
We're gonna disagree about that, okay?
Well, if it's just to prove his convicted felon status.
No, they're going to prove whether or not, as listed in the indictment, whether or not they're acts in furtherance of the conspiracy. So a jury's free to believe. It's just because they introduce them doesn't believe that they have to view them as proof positive.
They haven't, but there's different evidentiary means for them to get.
But they get to choose that.
But they haven't filed the pretrial motions to, like 404B. They would have to file a 404B.
They're not required to do 404B. It's not mimic evidence. Okay.
On a burglary from 2011.
It's going to what they allege in the indictment. So they have to be able to show that.
So
prove
it's
it.
going strictly to his status as a convicted felon, because that's the only thing that they've alleged.
Well, it's part of the elements in terms of, because one, you guys show whether or not he's a convicted felon or not. So yes, that goes to one aspect of it, but it's not, as an old chief, it's not the sole aspect of it. They've got multiple reasons as to why they're seeking that particular evidence. So,
and Your Honor, all I'm saying
if it was just that, then I would more agree with your particular assessment that the 403 balancing test would tip. In this particular circumstance, it goes to more than that.
But they haven't provided the pretrial notice to use it via other evidentiary means or vehicles. So in other words, that they can say, oh, well, it proves Mr. Shannon Stillwell has a propensity to do this, or whatever their argument is.
But they wouldn't be able to argue that. That would be error for them to argue that.
Well, let's just say that it proves his gang membership. Just, that's an example. They would have to file.
As in the indictment.
And they would have to file a 418 notice.
We talked about this before.
And those aren't listed on it. That's what I'm saying.
This isn't other acts evidence.
Well, then what is it? It's just proof of conviction.
It's overt acts in furtherance of the conspiracy.
They're not listed as overt acts on the indictment.
That's what that's how the indictment's read. I read the indictment.
I'm not disputing that they can get into overt act 98. All I'm saying
55.
is I'm not disputing that at all. All I'm saying is they can't bring in certified convictions after certified conviction after certified conviction as an element of that act.
It's only one element of whether or not he's a convicted felon.
They only need one conviction.
But that just goes to show. But it's more than that. They're going to show one. I mean, and look. You've asked. You're having discourse with the court. Yep. I'm just saying that it also goes to show whether or not they committed, or your client, whether or not they can prove your client committed any of these acts in furtherance of the conspiracy. Now, they may be able to show he's a convicted felon, but if the jury doesn't believe the other stuff, then that's only one thing. Now, whether or not he can be convicted of something else is another thing. But it is part of their proof in this case. I think it goes to multiple reasons. But State, you have anything else you want to add?
Yes, Your Honor, a couple of things. One, the state does not have to allege every overt act. And two, these are also intrinsic acts, and they don't have to be provided as with pre-trial notice of intrinsic acts. These are all part and parcel of an alleged conspiracy that we have charged the defendants with in count one. So this argument about 404B fails. The argument about pre-trial notice fails, and this is.
I still have to apply 403 though.
Oh, I do. I didn't argue about 403.
All right. Okay.
I didn't.
Okay.
I just don't see how these are at all intrinsic to when they occurred before any RICO conspiracies alleged to have begun. And Your Honor, I appreciate you hearing me out.
No problem.
And there's one other issue that we could take up, but while the jury's out, we might as well now. There's a photo that the state has indicated that they wish to admit, likely through a witness this afternoon. It's 26Q. It's been previously marked as 26Q. Your Your Honor, I would just describe it, it's a still off of a body cam.
Can you
Yes.
see it? Let me see it.
And Your Honor, to add context, in this incident that we're litigating this afternoon, my client is alleged to have been involved in a car wreck.
Okay, what is 26Q?
That is the driver. Apparently, after the wreck, the police dragged the body. He's alive, obviously, but they dragged the body of the man from his car and placed him on the grass, and they didn't know if he had any spinal injuries, which he didn't have, and they told him to lay there on the grass and remain still. And so I think that's a depiction of the man laying on the grass, remaining still. I don't know why we need a picture of the man who was driving the other car, laying in the grass, remaining still, following orders. I think it gives
Is he on the phone or something like that? Or
I think he's talking to, in the body cam, I believe he was talking to a friend. But I think it gives the impression that this man was seriously injured and potentially can't move, which wasn't the case. And I just don't see the status, the state of this man that was unfortunately in this car accident. That has absolutely nothing to do with what we're litigating today. I don't see how a hit and run, first of all, I don't think it's even relevant to a hit and run, but to the extent that it is, certainly a hit and run would not be, I don't think even the state would argue that that would be in furtherance of any RICO conspiracy. So I believe that it would be, I didn't say anything about.
So you're saying it's relevancy? Is that what you're asking me to?
403, yes, it's confusion.
No, it's different. Right.
It doesn't have any relevance.
Relevant is a threshold issue.
Okay, it doesn't have any relevance.
Okay, all right. State, anything as to 26Q or Quebec?
Yes, Your Honor. For 26 Quebec, the state feels that it is relevant. The previously admitted 23 Quebec and 24 Quebec, which show this white Ford Fusion. Mr. Montgomery was the operator of that Ford Fusion. The state, that picture is just him laying on the ground, Your Honor, as you can see up there on his back. The state's not trying to get into whether he had some kind of back injury or spinal injury. It's specifically to corroborate what already Officer Cogdell has testified to and what Officer Raymond, the state tends to introduce that through, that there was two cars and there's a diagram of this intersection that the state tends to introduce, which is 27 Quebec. And so the state just wanted to have the jury to be able to visualize the driver of the other vehicles.
All right. Mr. Short, unless you have anything else, I'll preliminarily say that I'm going to admit 26Q or Quebec, okay?
Thank you, Your
Honor. All right. As for states, 30 Quebec, 33 Quebec, 31 Quebec, and 32 Quebec, given the pronouncements of the court, I'm going to admit those. However, you have one here, should say state, let's see, that would be 31 Quebec, where you would need to redact or otherwise not include the revocation matter. Okay, so that needs to be stripped out anyways, but, and we can talk about that later anyways, because I think that there's a lot of allied papers that you probably have that probably don't have any, that wouldn't go out to the jury anyways. So, I'll admit them, but I'll say that you will have to, at some point in time later, unless you're going to show them to the jury at this point in time.
On one of those convictions, it appears that there's one of the old Fulton County handwritten sentencing sheets, and then also the computer-generated sentencing sheet as well. So it's almost like it's double, it's the same conviction twice. I believe that's on the Gain case.
I think, Your Honor, that is another matter that we have no problem hashing out with Mr. Sharp
are you going to read it in any way to,
We're gonna read the computerized copy, because that's what we're gonna read.
all right. Mr. Sharp, other than your objections, is that all right with you, sir?
Yes.
All right, just make sure that you all, before, that you all, I mean, that is the state and Mr. Sharp, get together and figure out exactly what's going to be read. But I'll admit those or re-objection and make them continuing objections. Okay?
And Your Honor, if it's okay with you in front of the jury, I'm just going to say that my objections are the ones that I've previously stated and assume that we will remedy the extraneous papers at a later date.
Yes.
Thank you.
Okay.
Your Honor, just permission to come approach and.
Yeah, oh, yeah, you can, yeah, Mr. Kearns, go ahead and give those back, please. Okay.
Thanks.
All right. All right, before we go ahead and recall our witness, how much longer do you think we'll need, Mr. Sharp?
With this witness, I would say 10 to 15.
Okay, we'll probably call it a day after this. Okay, that's all right with you all. Okay, all right, okay. Anything else from some of our jurors? All right. Oh, bathroom break. That's right. Okay, folks, I'm sorry. I apologize. Let's just take, we'll be in recess 5 minutes. You all need, and do what you need to do, and we'll come back and we'll go ahead and finish up. We're in recess. Don't go anywhere. Don't go anywhere.